So hi, everyone. We're getting started right on time today because this is a really full hour and a half. Welcome to our amazing annual year in review webinar. It's now in its sixth consecutive year. I'm joined by James Netto, and the two of us are going to share some of the top international family law updates from the past calendar year from the United States and the United Kingdom. So I am going to be the first to start today, and I'm going to provide the US updates. I'm going to go for about 40 minutes, at which time I'm then going to turn it over to James to share the updates from across the pond. It is a very full hour and a half, as I just said, so we're always grateful for your patience as we get through the materials. We're going to provide our slides to the New York State Bar. They will be circulated to anyone who's registered, along with a recording of today's webinar. We are sorry to say, but we won't have time for questions in the Q&A. So today's first update is from the Hague Conference on Private International Law. Its governing body, the Council on General Affairs and Policy, abbreviated to CGAP, as you see, meets each March. As a reminder, CGAP is the body of the Hague Conference in charge of directing the organization's work, including its approval of future projects. The Hague Conference hosted the 2024 annual meeting of CGAP from March 5th through the 8th. So a few of the updates: the Parentage and Surrogacy Working Group met twice in 2024 and is proposing 3 additional meetings between the 2025 CGAP meeting and the 2026 CGAP meeting to discuss a potential instrument on parentage, specifically the bases for recognition of parentage, the grounds for refusal, and other matters concerning the recognition of judgments on legal parentage. The Hague Conference also organized and hosted a forum on domestic violence in Article 13B of the Abduction Convention, which took place in South Africa in June of 2024. After the forum, the Secretary General reflected that having dialogues like that in South Africa better equip everyone in identifying and addressing domestic violence under the convention. There will be additional dialogue in a meeting this year in Brazil. The 5th Malta Conference was held in September 2024. The Malta process was developed to promote cooperation with states with legal systems based upon or influenced by Islamic law for the resolution of trans-frontier family conflicts, particularly on issues of contact rights between children and parents and the recovery of child support. Among the key topics at the conference in September were the use of mediation in cross-border children's cases and making more of the Hague Conference's documents available in Arabic. And finally, the Hague Conference, the International Academy of Family Lawyers, and the Canadian government are co-hosting an invitation-only meeting in April this year in Washington, D.C. to examine the issue of international child relocation in the context of the Washington Declaration, which is turning 15 years old. Moving to the United States, the U.S. Department of State issues a yearly compliance report as mandated by Congress that includes statistics on all outstanding child abduction cases from the United States to other countries and explores some of the underlying reasons why certain cases remain unresolved. The report includes both countries where there is a treaty relationship with the United States under the Abduction Convention and the countries where there is no treaty relationship. The report looks at statistics for the year prior to its release. It lists countries that are quote unquote non-compliant. Non-compliance is defined under the International Child Abduction Prevention and Return Act, ICAPRA for short, which is the federal law that mandates this report. For 2024, the non-compliant countries remain generally the same as was in for 2023, except that Montenegro and Poland were actually added and no countries were removed from the prior year. The compliance report can be found at the State Department's website, which is there on the slide, travel.state.gov. As a note, ICAPRA turned 10 years old last year, and the U.S. Congress held hearings in early September to determine whether there should be amendments to the act and to question officials from the U.S. Department of State about the lack of resolution of some abduction cases. The State Department officials focused in their oral testimony on issues related to Japan and to Korea, with the latter being listed as non-compliant on the 2024 report. In the United States, the Uniform Law Commission, a nonprofit that brought us widely enacted family laws like UIFSA and the UCCJEA, our jurisdictional statutes, has a joint editorial board on uniform family laws, or JEB for short. The JEB is tasked with monitoring the enactments and interpretation of uniform family laws throughout the United States, and it periodically puts out commentary to assist in proper interpretation of its Uniform Family Law Acts. In November of 2024, the JEB put forth commentary on the UCCJEA, our child custody statute, specifically regarding cases where there is also an issue under the Hague Abduction Convention. The commentary made clear, including through hypothetical fact patterns, that the Abduction Convention does not fix a jurisdiction to resolve custody of a child. It distinguished custody jurisdiction as being determined in the U.S. solely on the basis of each state's enactment of the uniform statute, and confirmed that case law throughout the United States confirms that custody jurisdiction cannot be consented to through agreement of the parties. Separately, the ULC is finishing work on a drafting project related to judicial interviews of children in their parents' private disputes. When finalized, this act would provide guidance to judges to assist in deciding when a judicial interview is appropriate and put in place protections for the child and their parents' due process when a judge conducts these interviews. The project is up for final review before the entire commission in July of this year. And if approved and then enacted in a U.S. state, it would be applicable to judicial interviews in abduction convention, international relocation, and international custody cases within the state courts of the state that enacts it. So turning to cases and starting with the Hague Abduction Convention, one of the key elements that a petitioner or parent must prove by a preponderance of the evidence to secure the return of their child under the Abduction Convention is that the child was removed from or retained outside of their habitual residence. Since Minaski versus Talieri, the heavily fact and credibility-based analysis conducted by judges has become more difficult to predict and more onerous, time-consuming, and expensive to argue. This does periodically lead to parents who want to reach a settlement agreement. Frequently, parents, when drafting an agreement, include language, or at least attempting to fixing the children's habitual residence to a particular country. In the case of Baz v. Patterson, the parents did just that in an Illinois consent order. Their May 2022 Illinois consent order permitted the mother and child to relocate to Germany, gave the father summer and school breaks with the child, and agreed that the habitual residence of the minor child is the United States of America, specifically the County of Cook, state of Illinois. This order also reaffirmed Illinois' continuing exclusive jurisdiction to modify the order pursuant to Illinois' enactment of the UCCJEA. After some conflict in 2023, and while the child was in Illinois over the summer, the father filed to modify the custody order in Illinois. The mother then sought the child's return to Germany using the Abduction Convention. The father argued that the 2022 consent order set the child's habitual residence as the United States. Ergo, the child cannot be returned to Germany because the child, at best, was being retained in its habitual residence. The district court, applying Minaski versus Talieri, noted that parental agreement as to habitual residence is but one factor in the total analysis, and concluded that the remaining factors related to the child's living situation in Germany outweighed the parents' agreement. So the child was ordered returned. The father appealed, the Seventh Circuit affirmed, and the father petitioned the U.S. Supreme Court to take up the case, presenting the questions of whether the parties to a Hague Abduction Convention case may waive their right to seek a child's return by agreeing to resolve child custody disputes exclusively in the United States, and whether parties should be held to an agreement as to a child's habitual residence in the same manner as to a civil contract. The Mother's Council argued that this was a simple case of applying Minaski versus Talieri. The U.S. Supreme Court went to conference on January 10th, just a few weeks ago, and denied cert. As a brief note, please be careful in reading this in any other case. In the United States, custody jurisdiction is exclusively determined by the UCCJEA, or in Massachusetts, the predecessor UCCJA. It cannot be agreed to. It is subject matter jurisdiction. It is also entirely distinct from the Abduction Convention. The Abduction Convention does not determine where parents must sue for custody. It is helpful to read the Uniform Law Commission commentary that I previously mentioned. The U.S. Court of Appeals for the Second Circuit in Urqueta versus Bowe focused on a key issue in resolving different elements of a Hague Abduction Convention case, the date that the removal or retention became wrongful. In this case, a child who normally resided in Chile was visiting his father in New York. The child first traveled to New York with the father on December 23rd of 2022. The child's travel authorization expired on January 8th, 2023. 2 days later, the mother filed a police report in Chile related to the father's retention of the child in New York. She engaged in conversations with the father and later argued that she consented to extensions of the child's trip. She then filed her return petition in district court on February 23rd, 2024. She argued that her conversations with the father were her consent to the child remaining in the U.S. longer, extending the trip so that when she then filed her return petition, it was still within 1 year after the wrongful retention. The district court disagreed, pinpointing the date of retention as January 8th, 2023, and therefore allowed the father to argue that the child was now settled in New York. The Court of Appeals clarified that a petitioner can consent to an extension of time for the child's stay, in which case the retention becomes wrongful at the end of the extension. But in this case, the court found that the mother extended her authorization for the child to remain in New York after there was already a clear instance of wrongful retention. The court found that she really didn't consent to the extension of time. She merely acceded to the circumstances she could not change after the father had retained the child. Therefore, her petition was denied and the Court of Appeals affirmed. On December 20th of 2024, the U.S. Court of Appeals for the Ninth Circuit affirmed an Oregon District Court's finding that children had no habitual residence. In the case of Nisbet versus Bridger, 2 children had lived most of their lives in Scotland with some time in Jersey. During this tumultuous time, their father murdered his mother, their grandmother, and was institutionalized. The children's mother continued living in the United Kingdom and facilitated access between the children and the father at the institution. On June 17th of 2022, the mother departed Scotland for Oregon with the children. The district court concluded that as of that date, the children had no habitual residence. They had no family or friends in Scotland, no meaningful relationship with their father. Their mother had an expiring UK visa. The father was institutionalized outside of Scotland, and the mother had made it clear that she intended to move to Oregon. Citing the Third Circuit, the district court concluded that where parental conflict is contemporaneous with the birth of a child, no habitual residence may ever come into existence. The mother had at trial described significant amounts of coercive acts by the father, which bolstered the court's finding. The Ninth Circuit affirmed, reading Manaski to say that no one fact is dispositive in habitual residence analysis, and confirming that the district court's findings should only be reversed when there's a finding of clear error. The father on appeal took umbrage with the court's finding of no habitual residence, but the Ninth Circuit disagreed. It said that while a finding of no habitual residence is rare and should be disfavored, it is not clear error to find no habitual residence if the case so warrants. One of the most commonly argued exceptions to returning a child under the Hague Abduction Convention is that doing so would expose the child to a grave risk of harm upon their return. In the case of Golan v. Sada in 2022, the U.S. Supreme Court affirmed a judge's discretion to consider ameliorative measures to safely return children, even when there was a grave risk. Many of the parents who argue this exception do so on the basis that the underlying risk relates to domestic violence by the left-behind parent. In early 2024, the district court in the Eastern District of New York reached its final conclusion in an extraordinarily long case, Sada v. Golan. The same case argued in the Supreme Court in 2022. The Supreme Court had remanded the case for the Eastern District to have further proceedings in June of 2022. However, in October of 2022, the mother passed away in New York, and the maternal aunt began retaining the child. She was substituted as a party for the respondent mother. The district court appointed an expert to examine the minor child for autism. The expert concluded that the child did not have autism, but exhibited post-traumatic stress disorder. So on October 30th of 2023, the expert was asked to provide an opinion on the effect of removing the child from his current residential setting and returning him to Italy. The expert concluded that the risk factors and the lack of protective measures would exacerbate the child's symptoms if returned. The court then sought clarity on the Italian proceedings. After several expert affidavits by Italian lawyers from both parties and direct judicial communication between a U.S. Hague Network judge and an Italian Hague Network judge, it was unclear as to whether the minor child would be placed with his father, a paternal relative, or even institutionalized upon return. It was also unclear as to when the Italian proceedings would yield a resolution. So ultimately, the district court concluded that any risk of institutionalization, given the child's unique circumstances, was just too great a risk, and therefore the court denied the father's petition seeking his return. Another fascinating case out of New York involved a father's request to return his two children from New York to a third country, not their habitual residence. The children were subject to a Ukrainian custody order and then ongoing Ukrainian proceedings. After Russia invaded Ukraine, the mother asked for the children's travel documents to take them out of Ukraine. The father, who was outside of Ukraine at the time, delivered the documents by representative, but asked that the children be brought to him in Dubai. Instead, the mother took the children to Poland and then the Netherlands, Spain, and on July 11th of 2022, she brought them to the United States as part of DHS's Uniting for Ukraine program. She didn't inform the father that she did this. The U.S. Department of State assisted him in locating the children, so in March of 2023, he filed a petition under the Abduction Convention. On November 21st of 2023, the Ukrainian courts issued a decision giving him residential custody of the children, although the mother then appealed that order. The Hague case had a lot of procedural complications, but for our purposes, the mother did argue that returning the children to Ukraine would expose them to a grave risk of harm. The father at the time of trial was actually residing in France, not Ukraine, so he argued for the children to be returned to France. The district court concluded that it was permitted to do that the drafters of the convention specifically did not require that a child must always be returned to their habitual residence, and the State Department has confirmed that over the years. Therefore, the court ordered the children's return, but to France. In reaching this conclusion, the court actually found that the children could be returned to Western Ukraine without exposing them to a grave risk of harm. So the mother appealed, and the Second Circuit affirmed in part, but remanded. The Court of Appeals disagreed as to the grave risk issue and found that a return to Western Ukraine would expose the children to a grave risk of harm. But the Second Circuit also said that the convention permits, as a temporary ameliorative measure, a court in certain rare circumstances to return a child to a petitioner who is not himself in the place of habitual residence, but temporarily in a third country. The return order was redrafted on remand, and the children were ultimately sent to France. Interestingly, on December 23rd of last year, many months later, in the case of Yuriovich versus Hirahovna, a district court in Montana ordered a child returned to Western Ukraine, finding that a return to Odessa would expose the child to a grave risk, but a return to Western Ukraine would not. That return order is currently stayed pending appeal, in part because if the order were reversed, the mother and child may be unable to return to the United States, having given permission to live here under the Uniting for Ukraine program. The Hague Abduction Convention is really a provisional remedy to physically situate a child after an abduction, so it doesn't really resolve custody jurisdiction, as I've said a few times already today. It doesn't determine where a parent must file a lawsuit for custody. In the United States, that is exclusively by state statute, with each state enacting its own version of a uniform act that determines initial and modification custody jurisdiction. This uniform act also provides for the recognition of a foreign court's jurisdiction in appropriate circumstances and aims to have one and only one prevailing custody order. Although in the international realm, that's not always accomplished. There was a particularly complicated jurisdictional case that involved Michigan, Texas, and India, the case of In Re JSN, which went before the appellate court in Texas. The parents started litigating over this particular child's custody in Michigan when the child was just 2 years old. Michigan issued an initial child custody order. The father was residing in Michigan with the mother residing in Texas, and the child then rotated between the two US states every 3 months until June of 2017. It was in that month that the father, with the mother's permission, took the child to India. It was intended to be a 3-month trip, but was extended by consent to an additional 3 months. So come September of 2017, the mother travels to India, but was refused access to the child. The father then filed a lawsuit in the Indian courts, claiming that Michigan, which presumably under this fact pattern had continuing exclusive jurisdiction over its order under the UCCJEA, with the father being a resident there. He argued that it lost jurisdiction because he had now left Michigan. On November 15th of 2018, the Indian court scheduled a hearing, and while the father was on his way to court, the mother dismissed her claim in the Indian court, retrieved the child from her in-laws' house, traveled 24 hours by land to Nepal, then traveled to China, and then home to Texas. After various appeals in India, the Indian courts concluded that India had child custody jurisdiction. But in April 2018, while the Indian courts were in the thick of its litigation, the mother sought and secured an ex parte order from the Michigan courts. In October of 2018, Michigan then declined to address any custody issues further because no one was living in Michigan. So on that basis, when the mother got back to Texas in November of 2018 with the child, after her very long and circuitous journey, she sought to modify the Michigan order in Texas. The father argued Texas has no jurisdiction, India does, and Michigan has lost its jurisdiction. He argued that even if Texas determined it had jurisdiction, the mother had abducted the child from India, and the Texas courts must decline jurisdiction based on her wrongful acts. The Texas court disagreed. It determined it had jurisdiction to modify the Michigan order. It did not recognize the Indian court's jurisdiction, and the Court of Appeals of Texas affirmed. So it's rare that we have international child support cases, in part, in my opinion, because of our system of state agencies that often address child support matters for parents. But there were a few in 2024 that warrant some mention. The California Court of Appeals addressed an issue, albeit in an unpublished opinion, that is critical to understanding international child support under the uniform statute that dictates jurisdiction and enforcement in the United States, which is UIFSA, the Uniform Interstate Family Support Act. In the case of Alameda Department of Child Support versus TO, it is absolutely undisputed that the parties had a Chinese child support order from 2018 that required the father to pay 2,500 yuan, which at the time of the California case was about $347. It was appealed and affirmed in China. It was final. After that order, the mother and child then moved to Michigan, then New Jersey, and the father moved from Nevada to California. So on November 30th of 2020, the State Child Support Office in Alameda County filed to establish child support. Note, establish child support, not modify the Chinese order. The father fought jurisdiction, arguing that there is a final child support order from China. This is where I remind you that when you're dealing with these child support cases, you need to look at your US state's enactment of the Uniform Interstate Family Support Act. In the definitions section, there is a definition of foreign country. If we are looking at whether a Chinese order should be enforced, we need to look at the definition of foreign country and determine whether China is considered a foreign country for child support purposes under our act. There are 3 categories of foreign countries in UIFSA. 1, foreign reciprocating countries. 2, convention partners with the US under the Hague Maintenance Convention. And 3, a country that has enacted a law or established a procedure for the issuance and enforcement of support orders, which is substantially similar to the procedures in the Uniform Act. The California trial court concluded that China fell into none of these categories. It certainly didn't meet the first 2 categories, but on appeal, there was a question as to whether China met the requirements to fall under the 3rd category. The problem in this case, however, was that no party presented any evidence that China had enacted a law or established procedures for the issuance and enforcement of support orders substantially similar to the Uniform Act. I actually question whether a parent needs to affirmatively raise this issue or whether the court may do so if no one contests it. But nonetheless, here in California, the lesson is that you should consult your foreign law expert and be prepared to make the argument, particularly if the other country doesn't fall into one of the first two categories. Because China fell into none of the categories, or so the court said, the Chinese order was not going to be enforced, and the California courts could proceed with establishing a new child support order. Another international child support case related to currency conversions, another thorny issue. In this case, Stone versus Henneke, the Ontario courts issued an order that required the father to pay monthly child support of $1,003 Canadian, among other things. There was a provision for interest on arrears. The order anticipated that the mother and child would relocate to Vermont, but the order did not address what would happen if upon child support after the relocation, nor did it provide for currency conversions between US and Canadian dollars after the relocation. So the mother and child relocated, and later the father then moved to New Mexico. The Ontario Support Agency stopped providing services to the mother, so she went to Vermont for help. The Vermont Child Support Office converted the Canadian dollars to US dollars using the Bank of Canada exchange rate in effect on February 23rd, 2010, the date of the original Canadian order. This then resulted in an obligation of $953.69 per month for child support. The Vermont Office of Child Support collected this, but it didn't adjust the amounts or address the fluctuation in exchange rates. The father paid it, he didn't object, he didn't seek to modify it. Then come 2020, some problems arose because the child stopped residing with the mother. At that time, Child Support Office in Vermont sought to modify the child support obligation to $0 and asked the court to calculate arrears. There were some claims that the father might have been owing arrears upwards of $10,000. He, of course, argued against that, saying that Vermont child support offices should have applied the exchange rate in effect at the time he made every single payment. The magistrate concluded it was acceptable to calculate using the exchange rate as of the time of the order, but that the arrears should have used the exchange rate in effect on the first day of each year. Using that calculation, the father actually would have overpaid, not underpaid, by more than $11,000. The magistrate ordered the mother to repay the $11,000, so appeals ensued. The Supreme Court of Vermont noted that UIFSA authorizes the family division to do what it did. It also said that UIFSA does not specify a particular conversion method. And so the Child Support Office's decision to convert amounts as of the date of the Canadian order didn't violate any law. Converting between US dollars and Canadian dollars is not a modification of the order. The Supreme Court affirmed the order as to the currency conversions, but it vacated, saying that the mother didn't have to pay the father the overpaid monies because it would be inequitable. This is just a convoluted way of saying to address currency conversions when you're negotiating an international child support agreement. One more international child support case is one from Florida. A father was paying child support according to an Australian child support order. The mother and child then sought to relocate to the United States, so the Australian courts modified the child support order so that there was no direct child support. The mother and child ended up in Florida, and the mother took the opportunity to try to modify the time sharing and to register and modify the child support order. Let's put a pin in the custody modification that actually wasn't addressed in this particular appellate opinion, and it has its own issues. But for child support, the lower courts in Florida found several times that it was going to proceed with a modification of the child support order. Believing that to be the incorrect outcome, the father petitioned for an order to affirmatively prohibit the trial court from assuming jurisdiction. The Florida Court of Appeal agreed with the father. It concluded that Australia was not a party to the Hague Maintenance Convention. In other words, it looked at the definition of foreign country in UIFSA, which we all now know we have to do. It classified Australia appropriately, and it looked at the correct section within UIFSA and determined that Florida could not modify the Australian child support order unless and until Australia lacked or refused jurisdiction under its own laws. The mother had not first attempted to modify the order in Australia, and there was no evidence that Australia would refuse jurisdiction or lack jurisdiction to modify its own order. Therefore, the order to prohibit the Florida trial courts from proceeding was granted. Of course, as family lawyers, we know that marriages often end in divorce. The Connecticut courts addressed a fascinating international divorce issue in 2024. And again, it revisited it in the final divorce hearing early this month. In this case, the parties Korshanova and Pershin were married and seeking to dissolve that marriage in Connecticut. The question before the Connecticut court was whether this couple was actually legally married. The husband had been previously married, but his first marriage was dissolved in Crimea, which is in the part of Ukraine that the United States recognizes as being occupied by Russia. His first divorce was decreed by Russian authorities. If the Connecticut court does not recognize a Russian divorce decree issued in an occupied territory, then the first divorce never happened for our purposes, and therefore the second marriage could not have been legally contracted, making it a nullity. The wife submitted several documents from the internet purporting to say the marriage and divorces in occupied Crimea or in Donetsk and Luhansk are not legally recognized in Ukraine and not valid for U.S. immigration purposes. She also provided an expert witness and testimony from the former, presumably ex-wife of the husband. The Connecticut court examined in a motion to dismiss hearing in 2024, and then again in the divorce hearing, which resulted in the final divorce order in 2025, whether the Crimean divorce decree was to be recognized as a matter of comity, and then whether the second marriage at issue here should be recognized. Ultimately, the court found insufficient evidence to not recognize the Crimean divorce decree as a matter of comity. Therefore, the husband was legally divorced and could remarry. Separately, the court examined the second marriage through the equitable remedy of practical recognition, something that's not available in every U.S. state. For the equitable analysis, the court opined that if the spouse attacking the validity of the marriage had accepted benefits in the marriage and had expectations and reliance on the divorce decree of the prior marriage, he should be stopped from arguing that the prior divorce was invalid and or the marriage should be void. In this case, the wife had acted throughout the marriage as if she was legally married to the defendant, and she had accepted the benefits of that marriage. Therefore, the second marriage is also recognized. Therefore, the parties are getting divorced. They're not getting an annulment. The wife's request to annul the marriage was denied. When simultaneous divorce lawsuits are filed in the United States and another country, we often see arguments of forum nonconvenience as a way to seek to dismiss one of the lawsuits. In a very short opinion of Texera versus Texera, the appellate division of the New York Supreme Court affirmed the dismissal of a wife's New York divorce because New York was an inconvenient forum. The couple were Brazilian citizens, married in Brazil, and had been married for 20 years, of which they spent less than 4 of those in New York. The family had relocated to New York in 2017 for the husband's job, but he had not lived or worked there since 2021. Their child had barely lived in the state. They had significant assets in Brazil, a home, other real estate, a company, a car, bank accounts, other accounts. The wife initiated the New York divorce action first. Then the husband filed in Brazil. In the New York suit, the husband submitted an affidavit from his Brazilian lawyer that stated that under Brazilian law, the courts have exclusive jurisdiction over all their Brazilian-based assets, even if a New York court rendered a divorce judgment over those assets. So regardless, there's going to be litigation in Brazil, even if New York decides to proceed with the divorce. So the court dismissed the wife's argument that the Brazilian discovery process was less efficient and inferior to New York discovery processes. The wife argued that there were domiciliaries in New York, although the court was questioning that because of some paperwork she had signed a few years earlier. All of that was not determinative. The New York court concluded it could have jurisdiction under its law, but still dismissed the case because it was an inconvenient forum. And that's exactly what it did. It doesn't matter that the wife was first in time to file. So when a divorce comes to a division of the parties' finances, this is a very complicated issue when the assets are in another country and are dictated by the law of that country. So we're going to take an example that my English colleague will enjoy. It's the example of the de Suarez de Alwans. They divorced in London. The ex-wife continues living in London. The ex-husband lives in either France or Monaco. Their primary marital asset was a Delaware corporation. The corporation owns winemaking operations and vineyards in Argentina. During their divorce, the English court ordered the sale of the Delaware corporation, set a sale price, and put the ex-wife in charge of the sale. But before the sale process began, the ex-wife or the ex-husband announced he'd transfer all his shares to some entity in Uruguay. So the wife sought to enjoin the Uruguayan entity into the English divorce proceedings. The English court did so. It agreed, but the entity never appeared, and it's questionable as to whether the English courts had jurisdiction over this Uruguayan entity or whether service of process was proper. Nonetheless, the English courts, they kept calm, they carried on, and the court entered an order voiding the ex-husband's transfer of his shares. But he, of course, disregarded the English orders. So the ex-wife turned to the Delaware courts. She asked the Delaware courts to recognize and enforce the English court's orders under the principle of comity. She specifically wanted the Delaware court to transfer the ex-husband's shares to her and record the transfer in her name. She had a few problems, though, and she really didn't have any success in the Delaware courts. First, the Uruguayan entity was an indispensable party to the Delaware lawsuit, and unfortunately, the Delaware court concluded that it could not be joined, making it impossible for the Delaware courts to proceed. The entity owned stock in the company and held certificates for the shares, so the Delaware court could not set aside the husband's transfer of those shares. His shares no longer existed in his name. They belonged to an entity in a completely different country. The ex-wife argued that the Uruguayan entity could have or should have addressed the matter in the English courts, but chose not to. True, the English courts permitted the Uruguayans to be joined as a party, but the Delaware courts were a bit suspicious of this and questioned whether the English courts really had personal jurisdiction over this entity to obligate them to do anything. So would the Delaware court be able to join the entity? No. Delaware law is clear. The ownership stock in a Delaware corporation is alone not sufficient to expose the stockholders to service of process or to bring them into the suit. In fact, the Delaware court noted that the agreement between the ex-husband and the Uruguayans was that any dispute would go to binding arbitration in Argentina. The ex-wife had some alternative forms. She could go to the English court and seek contempt. She could go to Uruguay and file a lawsuit. Perhaps she could go to Argentina, but she cannot go to Delaware. And a final comment, the Delaware court expressed concern that some of the English court's judgments seem to fly in the face of Delaware law. I mean, Delaware law would govern the internal affairs of a Delaware corporation overseen by a board of directors, including in this case, the sole director who was not a party to the English proceedings, who would be stripped of discretion by the English court order. So no luck in Delaware. A slightly different property issue at divorce. When spouses divorce, they may need to address provisions of a prenup. An interesting case came out of Minnesota last year, the case of Koivu versus Koivu. The Koivus met and moved to Minnesota for the husband's job as a professional hockey player in the NHL. They then traveled to and married in Finland, where the husband was a citizen. The wife had been living in Finland when they met, although she's an Estonian citizen. The husband had retained a Finnish attorney to prepare an annuntial agreement. They met with the attorney, discussed it, executed it all within a few days of their wedding. The agreement was comprised of two separate documents, both of which agreed to apply Finnish law to their marital property rights, regardless of where their habitual residence or domicile was. In total, the documents provided that each spouse would keep his or her own property acquired before, during the marriage, and then if they divorced, the husband would buy the wife an apartment of a certain value adjusted for inflation. During their divorce proceeding, the husband's Finnish lawyer stated that he felt the choice of law clause was appropriate because the husband's employment made it difficult to predict the parties' future residence. The spouses lived in Minnesota for 5 years, had 3 children, and then separated in late 2019, and the wife petitioned for divorce in February of 2020. And the husband then sought to enforce the agreement, including its choice of law provision for Finnish law. The parties stipulated to appointment of a consensual magistrate to issue a binding decision, subject to appeal. The magistrate concluded that Finnish law does apply and that the agreement was valid. He then concluded that Finnish law provided that it was valid, and that the money the husband would owe to the wife could be calculated, and he therefore calculated that contractual obligation under the terms of the agreement. That caused everyone to appeal, and the Minnesota Court of Appeals concluded that the parties can generally agree on the law that applies to their contracts. There was no evidence that either party knew that the law would apply if it were not Finnish law. There was no other evidence that either of them knew what Minnesota law was or the law of any other US state at the time they signed their prenup. They didn't know whether any of that law would differ significantly from Finnish law. No one was seemingly trying to avoid Minnesota law. They had connections to Finland. Therefore, the magistrate was not incorrect. Finnish law applied, the choice of law provision was upheld, and this was a valid contract. So that's all from the United States from the past year. I'm going to turn the microphone over to James.
Thank you very much. Hopefully you can hear and see me. And I'm just about to do the magic that is this screen sharing. Can you see it?
It is coming up.
Perfect. Can you see
started
that?
sharing screen. There it is.
There it is. Excellent. So you can see that all right. Okay, thank you very much.
Sorry,
I've got
James.
various screens.
It looks like we have the presenter mode. Do you mind changing the display settings at the top? Yep.
Oh, yes.
And then swap.
Is that any better?
Yes.
There you go.
There you go. Yeah.
Excellent, great. I've got various screens, and in a bid to be sort of technologically advanced, I've confused myself. So hopefully you can see and hear me. So my name is James. I'm a partner at the International Family Law Group in London, and we deal with all sorts of international cases. And it's an absolute pleasure to be here alongside Melissa to discuss things from across the Atlantic. So I'm just going to give you a bit of an insight as to what's going on in London, as well as a couple of cases from the Courts of Justice of the European Union. Poor Melissa has to summarise God knows how many circuits and 50 states. I've got a slightly easier task in relation to the courts of England and Wales and a few courts in Europe. So we'll just delve into a few bits and pieces that stand out in terms of international cases, or ones that are just, quite frankly, interesting or have caught my attention over the last year or so. So hopefully you'll find them interesting as well. I realise we haven't got time for questions, sadly, at the end, but if there's anything that jumps out, or you want to tell me I'm wrong, or you want to discuss the case, please feel free to drop me a line separately. So this is the menu for today. We're going to start by talking about a few UK Supreme Court applications. One of the buzzwords that's coming thereafter is a move towards anonymity and transparency, and the balancing acts between the rights of families going through the private court process and transparency in the family courts, which is a very hot topic at the moment. Just to look at some international children cases, NCDR, which is non-court-based dispute resolution, i.e. stepping away from court, which is something that lawyers do surprisingly need to know a bit more about. Part 3, which is divorce for financial proceedings in the UK following a divorce abroad, the division of matrimonial assets, and what's going on in Europe. Fascinating, I know, right? Well, let's kick off with the first one, which is this lovely case, which is the father and Worcestershire County Council. I haven't just included it so I can use the word Worcestershire for you American guys. And this chap on the right-hand side is King Charles II. You're probably wondering what on earth this is doing in an international family law case. Well, this is a case that's currently pending before our Supreme Court. And Charles II there passed the Habeas Corpus Act of 1679. Yes, that's what we're dealing with the courts at the moment. So this application to the UK Supreme Court concerns a power that was guaranteed by the Magna Carta in 1215, which is if there is a prisoner who is being detained, you can issue this application and have the court determine whether the detention was lawful or not, right? I have no doubt the same principle applies in the US as well. It does in various other jurisdictions. But where does it come in family proceedings? Well, on the 9th of June 2023 in Worcestershire, some district judge removed children from the parents' care and placed the children into the care of local child protection services here, Worcestershire County Council. Happens every day across the land, but instead of the father appealing these orders, in his infinite wisdom, he decided to issue an application or a writ for habeas corpus for the production of his children to the court and get them out of local social services care. And this went before a High Court judge. And the beginning of the transcript of the hearing is contained within the appeal that went to the Court of Appeal subsequently. And lawyers in the room will know that this is quite an ambitious application. I mean, if you're really challenging the acts of a district judge with 1679 legislation, you've got a bit of an uphill struggle. Be that as it may, this case really does hit home in relation to due process. So the transcript goes as follows. I'll read you 5 seconds of it. The judge starts by saying, Mr. X. He replies, good morning. What is it you're asking me to do? I'm asking for a writ of habeas corpus. Judge, you can't have it. What? You can't have it. It's an ill-conceived application. Why is it ill-conceived? Because it has no application in this case. It's hardly ever used anymore. Go and appeal. He then says, well, I've tried everything. No, you haven't appealed. Every appeal I filed was turned down, my lady. And the judge goes, well, that tells you something, isn't it? You're not getting a writ of habeas corpus. It's inappropriate. It's wrong. It's not the correct process. Goodbye. The Court of Appeal looked at this case because the father subsequently appealed his dismissal of his application, and the Court of Appeal went as far as saying that this interchange we have quoted demonstrates a complete failure of proper judicial process. The Court of Appeal had said that the judge clearly made up her mind before they had even said anything, and it was blatantly unfair. The father was hardly allowed to say a word thereafter. So the Court of Appeal, when considering this father, who, by the way, is acting as a litigant in person, so I think it's called pro se for you guys, the Court of Appeal found that the High Court hearing had been manifestly unfair, it was procedurally unsound, and set aside that decision, but still substituted it with a decision of its own, also dismissing the father's application for writ of habeas corpus. He has now appealed to the UK Supreme Court, our highest court, and the UK Supreme Court is now dealing with a case involving legislation that is 346 years old. So as always, you can count on the Brits to be at the very cutting edge of law here. So it may well be that this slightly crazy pro se litigant in person father is right, and we have been wrong for the last 346 years. If I were a betting man, I know which way I'd bet. In the climate, however, where we're seeing more and more cases coming through the courts of free citizens, citizens of the land, sovereign people, which I don't know has reached your shores yet, but it's certainly coming across the UK and in Australia as well. I know that as well. It's growing and growing. This is really an area to watch. So we find out next month as to whether he has been successful. Moving on to another Supreme Court case. This is a set of tragic cases that have gone to the Supreme Court as well. These cases are two conjoined appeals which relate to parents, two sets of children in separate cases. Both children were extremely ill, and they were known as they were involved in what's known as end of life proceedings in the family division, which is where the local hospital or local hospital trust will apply for a declaration that it is in the child's interest for essentially machines to be turned off or not to provide certain medical treatment, which will inevitably cause their end of life. Tragic cases, enormously challenging, always very high profile, always very emotive and very challenging all across the board. So in these two cases, Abbasi and Zainab, they sought in due course, whilst the proceedings were ongoing, for the lifting of what's known as reporting restriction orders. And these were orders made by judges in which the judges prevented the naming of treating physicians, so the doctors who were tasked with dealing with these very, very ill children. They couldn't be named and some would say shamed in the public domain. So whilst the hospital here was King's College Hospital in London, they were known to have the children in their care. The individual doctors it was prohibited for the individual doctors to be named. The Court of Appeal, however, when discussing this, had to balance the Article 8 rights, which concern the right to private and family life of these hospital staff, and the Article 10 rights, which is the right of freedom of expression of the parents. This is a very, very delicate balancing act that needs to be undertaken. And in the age of social media and X and Twitter, you can imagine what certain people would be saying online in relation to treating physicians for very, very ill children. Which of these two will prevail? Will the doctors be named, or will the parents get away, or will they have their own private privacy rights upheld? That is currently before the UK Supreme Court. It is a fascinating case. It will be quite high profile when it comes out. So that is a real one to watch for. Alongside this, this comes in a context, and I'll go over to the next slide, in relation to anonymity. One of the prevalent issues across this year that's just gone, end of the year ahead, is the idea of opening up the family courts within reason to the media. This is something that the president of the family division in our jurisdiction is very, very keen on. He's exploring issues in relation to the naming of families, judges, not children, but people involved in these cases. For example, in our divorce cases, oftentimes you'll find that the parent, the husband and wife in a divorce case are named publicly by name if it's in the public domain. This is a case involving journalists involved with the case of Sarah Sharif. So Sarah Sharif was a 10-year-old girl who lived in Surrey and who was murdered by her parents very, very tragically. And then her parents ran away to Pakistan from where her father was hailed from with 4 other children. They were taken to Pakistan, and then from Pakistan, it was very, very high profile this, the father called local social services and the police in the UK and confessed to the murder of the child. There was no extradition treaty in place between the UK and Pakistan. However, the Pakistani authorities took this extremely seriously. They took the children in Pakistan into care, and thereafter, the father and his wife returned to the UK where they were subject to criminal proceedings. The father was found guilty of the child's murder and was sentenced to life in prison. The child who at the center of this, Sarah, who had been murdered, alongside her siblings, were the subject of quite long-running, extensive proceedings in the local family court in Guildford, Surrey. The question that then came before the court was really, to what extent should the public at large, and journalists in particular, have access to the material, have access to the names of the social workers involved in the cases, and have significantly access to the names of the judges who dealt with the case at first instance. They allege that, or they think it's in the public interest that if a judge is dealing with a family's case and that child, something very bad happens to the child, it may be in the public's interest to know who took this decision. This went before Mr. Justice Williams, one of our High Court judges, in December 2024. He produces a very long judgment in which he says he doesn't see there being public interest in the judges being named and again named and shamed. This has gone to the Court of Appeal, and the Court of Appeal has challenged the decision to restrain the naming of any judge who heard the historic proceedings concerning Sarah Sharif and her siblings. And on Friday of last week, Friday just gone, the Court of Appeal has said that the judges from the local family courts can be named, which is really, really significant. Their names will be put in the public domain on Friday of this week, so in a few days' time. 2 of these judges have since retired. 1 is still in service and sitting. Let's see how this plays out. The Court of Appeal directed that the judges were to have 7 days' notice of this. And in the judgment of the Court of Appeal, they said, to quote it, HMCTS, our courts and tribunal service, can put sufficient protection in place ahead of the names of the judges being placed in the public domain. So you will see the tide turning in relation to keeping things very, very private and a real move towards transparency. And Louise Tickle is one of the journalists. It also involves the Press Association, the BBC, and all the big hitters in the media sphere who intervened in this case. Now, a new separate case, another one, just to move on to the international dimension, is this case. So it hasn't been reported publicly yet, and that there's no judgment yet. But this case concerns a child called Child M. Child M is now 14 years old. In the summer of 2024, just gone, he was told that he was traveling with his family from London to an African country, and his family are British African. The identity of the country has been kept confidential. He was told that his grandmother was unwell and the family were going to visit grandma. Upon coming to this African state, he was told immediately that he wasn't actually here to spend time with his grandma. He was here to be placed in boarding school. And the reason behind this is because this 13-year-old boy in London was acting up at home. There was evidence to suggest that he was involved with the wrong crowd. He had been suspended from school a few times. There were some allegations of him being involved in knife crime, of him coming home with new belongings, of new designer clothing. Something very fishy was going on, say the parents. And it was for this reason that the mother and father, acting in unison, decided to exercise their parental responsibility and take this child to an African state and leave him there and place him in an African boarding school. They say they were doing so to protect him from gangs in London. It is no secret that young people involved in gangs in London, it's a very real concern for many, many parents. This incredibly resourceful young man managed to escape the boarding school in this African state. He contacted the British High Commission in that African state, who thereafter referred him to social services, who thereafter referred him to a group of lawyers, who thereafter instructed a solicitor in London, which is me. I am this guy's litigation friend. I'm bringing proceedings on his behalf to start to seek his return home. The question that is puzzling this High Court judge is whether he should order, Mr. Justice Hayden, who is here in this case, whether the judge should order that this now 14-year-old boy should be returned home to London. And on the one hand, the parents were exercising their parental responsibility. They were exercising their parental rights to protect him ostensibly from harm. On the other, his wishes and feelings, which as a 14-year-old you need to place a lot of weight on, his wishes and feelings are abundantly clear. He wishes to return to London. And what is the court going to do? Well, we find out in a few weeks' time. On the 18th of February, it comes back to court for a final hearing. As part of this, the press are also extremely interested in this. If you Google boy boarding school Africa, you'll see a myriad of results online, including this one on the right-hand side from the Daily Mail. It has spawned intense debate in the comment section. It has spawned debate within friends and family. My own parents have a view, but my colleagues at work all have a view as well. And whether you should override the parents' decision-making process. And also, if he were to return to London, where is he going to live? It's not easy just to plonk him back with his parents in London. It's a very, very, very finely balanced case. I don't know whether it's going to end on the 18th of February or whether there is an appeal out of it. All I would say is watch this space. Were his parents from a different background, he might have been placed in a boarding school in the UK. I dare say many other countries, US included, might have placed him in some sort of military school or something like that, or something to instill discipline on him. The fact that he's been placed and left alone in Africa is a very different dimension on it, or should it be? That's something. Those are all points that the judge has to grapple with. On a side note, and forgive me for pointing out the obvious, a word of advice is never look for intelligent legal discourse in the comment section of any newspaper, because you will see over here some of the comments that were left on this article, which were mind-boggling. I do enjoy the comment from Susie Q in London Town saying, doubt he will win, barristers are just parasites. I sent that to the other lawyers in this case for a bit of a chuckle. And inexplicably, another thing to blame on Brexit, how much will the UK pay to them in compensation? God knows what Brexit has to do with any of this, but there we go. But yes, that is a case that's ongoing. It's taking up quite a lot of airtime in the UK, and we'll see where it goes come February 2024. Now, away from wardship cases, so those are non-Hague abduction cases, non-Hague child litigation cases, we also have some Hague cases. First case, this is the case of Ree, is an appeal to the Court of Appeal, where the mother had abducted a very young child from Australia. The father had issued Hague Convention proceedings in the UK, and the mother defended those proceedings. She sought to rely on Article 13b, the grave risk of harm defence, and in the process of this, a psychiatric assessment had been ordered of the mother. At first instance, the High Court had refused to allow for the child's return. In doing so, they relied very, very heavily on the report of a psychiatrist that had been instructed jointly. And the psychiatrist was assessing the nature of the impact on the mother's mental health on returning to Australia, and whether this in of itself could establish a grave risk of harm to the child, whether that would be otherwise placing the child in an intolerable situation. There is a stream of case law in the UK about whether the mental health of a caring parent and the primary carer child should or should not give rise to an Article 13b defence. In this case, it's surprisingly, in my view, and I don't know whether this shows the tides are turning, the Court of Appeal overturned the summary return order. They said that the assessment had to be there being a significant risk of deterioration of the mother's mental health, and not a risk of significant deterioration. The positioning of those adjectives is complex, but requires some analysis. Now, in those cases, you have to analyze whether the risk is significant rather than there being a risk of significant deterioration. Requires very careful analysis. This is one of the most common defences seen in terms of most common tools seen in Article 13b defences in Hague cases in the UK at the moment. Whether this will have a long-term impact on these defences, it remains to be seen. But it's certainly an area to watch for the system going forward. Now, in terms of another 13B case, which I think you guys will find, oh, sorry, before we get onto that, I'm just seeing this case. We'll jump ahead a bit. I'm reliably informed that's a Philadelphia Eagle. I had to Google it. Forgive me, not a sport that has reached our shores just yet. This involves a case of a mother who brought an 11-year-old and a 9-year-old boy to the UK. Neither the mother nor the children had a connection with the UK whatsoever. And the father issued proceedings for the children's return to the US. The mother and father had actually been involved in quite extensive proceedings before Judge Love in the court in Pennsylvania, domestic proceedings, and there were protection from abuse proceedings and custody proceedings in that state. The mother's litigation history did her no favors, quite frankly. It was described by various judges in various different guises that the mother had a subjectively, and that's the important word, subjectively entrenched belief that the children were at risk of sexual harm at their father's hands. The judge, in determining this in Pennsylvania, made no findings on that basis, could not find any make any findings of sexual abuse of children, and issued a joint custody order. Thereafter, the mother abducts from the US to the UK. On her arrival, a day after she arrives, she claims asylum in this jurisdiction. She says she cannot return to the US as a result. And pursuant to case law in our Supreme Court, which I know has been mirrored in multiple jurisdictions across the world, if there is an extant claim for asylum, it is difficult, if not impossible, to enforce any return order under the Hague Convention, because the two are so juxtaposed. Thereafter, a myriad of issues come out of the woodwork. The father is granted sole legal and physical custody of the children in the Pennsylvania court, and there is also a risk of the mother being arrested on her return. The UK authorities repeatedly reject her asylum claims, and the matter thereafter goes to the President of the Family Division for final consideration of whether the children should be returned to the US. The court clarified that the court is not prevented from determining the Hague return case if an asylum case is pending. If asylum is granted, it's the final nail in the coffin and you can't get a return. But this is very different when it's pending. The children's return was ordered, notwithstanding the fact that the asylum case was pending and thereafter dismissed. And it shows, I thought it was quite an interesting case to show the lengths perhaps that certain parents will go to in order to bring about an Article 13B defence. But this shows the High Court being quite robust in its approach. Would this have been different if the mother had claimed asylum, or whether her actions in the local family court in Pennsylvania had been any different? Goodness knows. But the children's return has now been ordered. Another Hague matter, this is a case of Re P involving an elder child. So this child was 15, I think 15 and a half by the time these proceedings were in court. So in this case, the mother and father previously lived in Spain. Thereafter, there were quite extensive proceedings in the family court in Spain. The father's parental rights had been terminated by the Spanish courts. This is when they were all living there. And afterwards, the mother was successful in relocating to Romania, and the child lived in Romania with her, and the father moved to England. So a lot of juggling around as well. The child was visiting the father in the UK. The child was retained. The mother sought return to Romania. You'll see the picture on the right is Dracula's castle in Transylvania, Romania. The judge at first instance was tasked with dealing with this application as to whether the child should be returned to Romania, and the 15-year-old was said to be objecting quite strongly. This went to the Court of Appeal. I find it quite unusual because it's a 15-year-old, and when it comes to enforcement involving children who are slightly older, the English court is very cautious indeed. It will not arrest a child, put a child in shackles, and shove a child on a plane at that age. It is just something that's just not on the radar of judges or our enforcement agencies. For a child at 15 to have an order against them, against their stated objections is quite something in my view, and this is exactly what the court did. The Court of Appeal overturned the non-return order. It queried the role that the father had in the child's life, the findings of the Spanish court, which were very significant for his parental rights to be terminated. The child's views were said to be incoherent about his life in Romania, and the Court of Appeal said that the child lacked insight and maturity. The child's return to Romania was ordered, notwithstanding his objections. Whether this child has set foot on a flight back to Romania or not, we do not know, but that is certainly something that the court was not shy of doing. The Court of Appeal says it's, reasons for enforcement or non-enforcement shouldn't be his age, because he's still subject to laws, the orders of this court, in the same way that a parent would be. But it's an example of one of the older children on the spectrum of Hague Convention cases, which of course ceases to apply after the age of 16. It's one of the older examples of children being returned, notwithstanding their objections. So moving away from Hague cases, one of the biggest developments we've seen are new powers entrusted to the court in relation to non-court dispute resolution, which is basically getting out of court and trying to settle things together. So one of the most significant changes has been an update to our domestic family procedure rules, and that in most cases you must consider utilizing some form of non-court dispute resolution before commencing legal proceedings. If you have some sort of race or urgency or need to issue proceedings, then there are rules around it. But judges are even saying now, once you do that, you then need to consider NCDR. If you do not, you may fall foul of a judge in these circumstances. And it's not just mediation, it includes arbitration, it includes collaboration, collaborative divorce, private financial dispute resolution hearings. This applies less so in children cases. To be blunt, I think there is always one party that stands to benefit with some element of delay by incorporating the status quo. But in financial proceedings in particular, you must always have an eye to non-court dispute resolution. So there's a case of NA and LA, which was a decision of Mr. Nicholas Allen Casey, sitting as Deputy High Court Judge. So irrespective of the parties' consent, he made it very, very clear that the court can now direct that the parties trot off and go and engage in non-court dispute resolution. So in this case of NA and LA, the court had previously heard that this was a return date following ex parte orders without notice orders made, which include a non-molestation order and an occupation order, i.e. an order that you have sole use of a family home, and also preservation for property orders in relation to properties in London. So on the same day that the ex parte orders were made, and presumably while still at court, the wife also filed a divorce petition. She made an application for financial remedy or relief following a divorce, and there had been no warning, no inter partes correspondence beforehand. She then made an application for spousal maintenance and as maintenance pending suit, so whilst the divorce is ongoing, for some sort of financial support, and for legal fees. Those latter applications hadn't even been listed, and the husband's counsel at the hearing before Mr. Nicholas Allen Casey, in this case of NA and LA, he described that the husband had been blindsided and floored by the wife's actions, having been given no notice that the wife intended to proceed with divorce, or even that their marriage was over. So the court decided in this case to stay the financial proceedings to allow the parties to engage in this, and recognizing that a serious attempt at resolution could benefit all involved, particularly children. Woe betide you if you don't even jump through these hoops, because you're looking at a judge being at best unimpressed, at worst making adverse comments and even cost orders against your clients or even against you. So bear that in mind. It is a shift in gears, perhaps, is the best way of describing it, where lawyers are always very keen to trot off to court. Moving on to litigation involving judges, you'll see our friend Mr. Putin smiling back at you. And the reason you might find this surprising is, well, you might see it surprising in a family law context, but this case went to the Supreme Court. I touched on it in our presentation this time last year when we were awaiting the decision of the Supreme Court in the case of Potanin. Now, Vladimir Potanin is the wealthiest man in Russia. He's the 59th richest person in the world. He's got an estimated net worth of something in the region of $31–32 billion. He's part of Putin's inner circle, and perhaps unsurprisingly, he's subject to pretty much every sanction under the sun. His wife issued proceedings in the UK following a Russian divorce under Part 3 of the MFPA 1984, and that allows English court to analyse whether the division of assets and property and money post-divorce in a foreign jurisdiction, whether that is equitable, and whether she could be allowed to start proceedings in the UK for basically a second bite of the cherry. The process previously was that somebody in the wife's situation would be applying without notice to the husband and seeking permission or leave to bring that sort of application. In this case, that was exactly what happened, and then on return, the judge subsequently allowed the husband's application to set this permission aside, alleging that the judge had been misled. This went to the Court of Appeal. It had a bit of a circuitous litigation history, but eventually it went to the Supreme Court. And it is all focused around the rules of bringing this sort of application and whether in this day and age it is right to make an application without notice, serve it on somebody else, and then say, here you go, mate, you now you have to set it aside. So the decision of Lord Leggett, in this case, the judgment of the UK Supreme Court, opens with Rule 1 for any judge dealing with a case is that before you make an order requested by one party, you must give the other party a chance to object. There are, of course, examples when this isn't necessary, but whether Part 3 falls into this bailiwick is a question for some scrutiny. It sets some very clear guidance as to whether these cases can be brought in this manner, and really an application hasn't effectively been left with there must be a real prospects of success to meet the thresholds at the leave application stage. So it's not just about setting it aside, it has to be the onus on the applicant to show a solid ground on which their application is based. Now, spare a thought here for Mrs. Anna Standish. This is quite a high-profile case that has gone through our family courts as well. It's also a lesson on be careful what you ask for. So Anna Standish is the ex-wife of a former chief financial officer of a gentleman called Clive Standish. He was at UBS. He was also a sheep farming tycoon, which is rather twee, but made him quite a lot of money. So in 2017, when they were married, the husband and wife were working together to plan their tax accordingly. The husband transferred £77 million of his assets, which included pre-marital assets, to the wife as part of a tax planning scheme, which had never been fully implemented, and the total wealth was around 132 million. So at first instance in the High Court, Mr. Justice Moore concluded that as a result of these this movement of money, the assets had become, quote, matrimonialized, but not, as the wife argued, her separate property. Accordingly, they were subject to the sharing principle when it comes to the division of assets in any divorce. The wife was dissatisfied with this and took it to the Court of Appeal, and the father also cross-appealed. And Lord Justice Moylan, sitting in the Court of Appeal, had said that the judge's application at first instance of the sharing principle had resulted in a, quote, unjustified division of the family's wealth in the wife's failure, because it focused entirely on title rather than the ownership of the asset or how it was used. So the transfer of assets did not convert the wealth into matrimonial property, and therefore subject to the sharing principle. And as a result, poor Mrs. Standish, her award was reduced from £45 million to £25 million, which is the largest ever reduction in UK divorce history. So buyer beware, appellant beware. Bear that one in mind, but it does serve to show the importance of properly considering matrimonialized asset and the sharing principle in UK divorce cases. Then over the next page, and just a quick one on conduct in divorce cases. So our Matrimonial Causes Act 1973 sets out when you're exercising powers in terms of dividing assets, what factors you bear in mind. And some are very, very common ground and used day in, day out, such as income, earning capacity, property, financial resources that each parent has, each spouse has, needs, standard of living, age of the party, all this sort of thing. One of the factors is conduct of each of the parties if that conduct is such that, in the opinion of the court, it would be inequitable to disregard it. And this was quite an interesting case before Mr. Justice Peel in the High Court, where he was tasked with considering conduct arguments. Historically, in English proceedings, there has been a very, very high bar in order to consider conduct being thrown into the mix, and whether, if you're a horrible spouse, that has an effect on the division of your assets, either way, against you. The judge goes through this, and there have been quite a lot of strong movements in children law cases where there has been a reassessment and a reset, some might say, in relation to the approach that the court takes into domestic violence in children cases, and whether that applies in divorce cases. The judge does say that this is a factor that's in statute, so it would be unusual to never rely on it, but says that it would be highly unusual to use that factor in general. The judge doesn't use it in this case of N and J. Perhaps it wasn't the right case, because in my view, there probably should have been findings. If you want to use a conduct case, you might want to rely on findings made in other proceedings, for example, children proceedings. What is interesting is the judge referred to one case where he thought that it was right to use conduct, and that was a case of Al-Khatib and Mazari. It's where the husband had abducted the children to Saudi Arabia. He didn't return them in breach of orders, and that the conduct was so egregious that it referred to an award in the divorce proceedings for the mother to have a fighting fund, a litigation fund, for her to start proceedings in Saudi Arabia seeking their return. So it's just one area of law that still hasn't, well, it's there may still be further work to be done in terms of conduct. I don't know if this was the case for it, but again, watch this space. So I just wanted to conclude by mentioning two very brief cases from the Court of Justice of the European Union. It's always nice to know what's going on in the European, well, in the, this is the European Court of Human Rights, forgive me, which the UK is subject to and is entirely separate from the European Union. There are two quite high-profile cases involving Article 8, and Article 8 is the right to private and family life. This case is a fascinating one of the estate of Leif Lindholm in Denmark. And Mr. Lindholm was a very, very, very devout Jehovah's Witness. And as a consequence of his religious conviction, he had given an advance medical directive refusing any sort of injections or blood transfusions. Mr. Lindholm was working on a roof one day and he fell through it, and he was rushed to hospital in a comatose state. The hospital knew that he had given an advance medical directive, but were monitoring him very closely and were tasked with dealing with the challenge of giving him a blood transfusion, which may well have saved his life, notwithstanding the fact that he had given a very, very clear advance medical directive, which was legally binding, saying that he did not consent to the blood transfusion. Notwithstanding that this advance medical directive was in place, the doctor in the hospital in Denmark administered a blood transfusion regardless. This in itself went all the way to the Danish Supreme Court, which said that because the patient was unconscious, unable to make his own decision, and unable to state his own wishes, the doctor was right, or within his margin, to administer a transfusion, notwithstanding the existence of a medical directive to the contrary. I do wonder what the American perspective on this would have been, but the Danish court upheld this. This gentleman, or rather when he passed away, his family, his estate, took Denmark to the European Court of Human Rights, and they sought a declaration that this was incompatible with his right to private and family life. The Strasbourg courts declared that the complaint was admissible, i.e. it is a complaint worth examining, but that the Danish court had not violated Mr. Lindholm's right to private life. It held that the decision of the Supreme Court, which upheld the decision of the medical professionals in effect, they held that that decision was necessary in a democratic society and proportionate to the aims pursued. Very, very, very controversial. I don't know what else could have been done for this Jehovah's Witness if he had given very, very clear medical directives in advance, refusing blood transfusion. It was more focused around him being unconscious at the time, but surely is par for the course if you're giving a medical directive. But there we go. Very, very interesting case. You'll see this bubbling away as well in terms of children in similar circumstances. We very regularly get these cases where children are being refused, are refusing to undergo blood transfusions for that reason, or similar inoculations and so on. So yes, watch a very, very interesting element of law all around the right to private life. And finally, this is just one case to consider, a very high-profile case as well coming out of the Strasbourg courts. This involves the Paris Accords, and I realise my audience and who is now in charge across the pond and the dicta that's come out of the White House in relation to that. So maybe the less said, the better. But this is a set of litigation from various bodies who sought to sue their member states for not doing enough to protect their citizens in relation to climate change and indeed following the accords reached in Paris about reduction of greenhouse gases. And that this in itself, the failure of these member states for not doing anything in terms of reducing their carbon footprint or reducing and not adhering to international law, and particularly the Paris Accords, this amounted to an infringement to their right to private and family life. And there was a group of cases, and the two most high-profile ones were there was somebody suing a mayor in Paris that was refused. There was a group of 6 Portuguese young people who sued the Portuguese state, saying that the state of Portugal was not doing enough in terms of protecting their right to private and family life by sensibly reducing pollution and greenhouse emissions from Portugal. That was dismissed, but for a procedural ground, which is that they hadn't exhausted the domestic remedies. But the Verein Klimasenioren, and forgive any German speakers on the call, which is a group of senior citizens, and specifically Klimasenioren is, as I understand it, translation for group of climate old ladies of Switzerland. They sought and successfully sued the Swiss state, alleging that the Swiss state was not doing enough. They alleged that the government was providing very weak policies, that it wasn't doing enough, that it was bogged down in administration, that there was no tasking of responsibility between the various cantons in Switzerland. They went and made complaints across the Swiss authorities. They went to ombudsman, they went to local authorities, they went to federal authorities, and each step of the way, they were alleging that nobody was upholding their right to private and family life by failing to properly grapple with a reduction in greenhouse gases and so on. Every step of the way, the Swiss authorities, the Swiss courts and decision makers sided with the Swiss authorities, and they took it to the European Court of Human Rights. Lo and behold, the European Court of Human Rights has agreed. Whether this triggers further litigation on a domestic front or even on an international front remains to be seen. Curiously, the House of Lords in the UK, they've noted this decision very carefully, and there's quite a lot of work, I understand, going into how to properly assess the impact of the litigation and what it means for the what the European legislation means for those in the UK. Remains to be seen whether at home, domestically, this results in any sort of litigation. You may think it's slightly strange for this to be in a presentation about international family law, but this is all anchored on the basis of appellants and applicants relying on their rights to private and family life being infringed by the inactions of the government. So watch this space. It may be something that gains quite a lot of momentum over the next year or so in the European Union. This case was one I referred to this time last year. We were waiting the decision, and in some quarters, this decision was met with quite a lot of surprise. So yes, it may well generate further litigation down the line. On that note, I think I'm just on time. Thank you very much for listening to me. I think that covers everything from my perspective. If you guys have any questions, please do let us know. I'm sure Melissa and I will be happy to deal with any questions by email. I understand that the presentations will be sent around by email as well, but all that leaves for me to say is thank you for listening, and thank you, Melissa, and thank you to the Bar Association for having us.
Thanks. It's so great to see you, James. Happy New Year to everyone. And James, I'll see you later this week.
Yes, yes. Thank you, everyone.